Further hearing the appeal to the estate of Dame Bernice Lake QC deceased against Attorney General of Anguilla.
Yes, correct.
My Lord, when we adjourned last night, I was working my way towards actually going to the Board of Assessments
You're about to tell us
decision.
why the board got it wrong.
Why the board got it wrong.
Yes.
But I do need to set it in context as to what it was that they were being asked to do by the parties, and particularly by the claimant. So, if Your Lordship will indulge me for a few more minutes, I will just, before I go to the board, look at some of that material, or invite the board to look at some of that material. Could I ask, first of all, that we go to page 679, which is Mr. Glean's supplementary report.
You just have to give me 1 moment, Mr. Howard.
Of course. Well, I should say, in relation to the question of timing, I think we lost a bit of time yesterday, but I hope I can make it up. If need be, we've allowed a reasonably generous amount of time, bearing in mind the fact that quite a lot of material has been canvassed already for the other appeal, or for the
Yes.
appeal. So, if I go over slightly, I might.
We might see if we can squeeze the other appeal a bit if you're still in full flight by 11.
Yes. Yeah. Well, I'll try not to be, but equally, I want to give the best answers I can to any questions that you might want to make, might want to ask.
Anyway, 679.
679.
And is this Mr. Glean's third report?
I think it is, my lord. Yes, although it's his second version of the first report. The intervening report was about
Yes.
injurious affectation. And he explains at 681 the purpose of this report to make some corrections.
Yeah.
Because he'd previously used a different date of valuation, not appreciating that the court had changed the statute by using its powers under the Constitution. And so he recalculates things. But for present purposes, can I therefore skip over what he says about the parcel? We looked at that in the other report yesterday. Your Lordships will recall the points that he made there about the desirability of the parcel as part of the overall area that could be developed. And if we go to 686, we see him explaining why he chose the comparables that he chose for the purposes of his valuation. And he sets out at in the bottom half of that page, under the heading Selection of Comparables, 3 factors.
So I think that again is focusing on the larger parcel, isn't it? Because he's
That's right, my lord, yes.
taking very big developments.
Yes, no, but at no stage does he say, let's just look at this as 10 acres on their own without consideration of anything else.
Or 10 acres as part of 110 acres.
Or as part of 110, that's perfectly fair to record, my lord, yes. He's always looking at it in terms of the 10 acres as part of the overall larger 126 plus 100 plus 126, 361 acres, I think it is in total.
But I think it's fair to say that he's looking at the larger parcel in order to arrive at a specific figure for the 10 acres.
Yes.
Yeah.
That's right. And so he says there are these factors that he's using as a guide. Has to be undeveloped, coastal, had to be at or in very close proximity to the coast, had to be development of high-end, the highest and best use had to be high-end villas or other similar upmarket tourism development projects, and sales prices from a reputable source and sufficiently close in time. And then he sets out on the next page various sales to which he's had regard. But they're all in point of time after the acquisition date, but that by itself, we submit, doesn't necessarily matter. It's always a question of fact, what a person would have paid on a particular date, and if you've got evidence that a year later, the market not having moved much, somebody paid X for a similar property, that's pretty good evidence of what somebody else would have paid on the acquisition date.
Sure, but I mean
it depends.
Isn't this whole methodology isn't something that is open to you now, is it? Because you're not pursuing an appeal in relation to the relevant parcel being the larger parcel. This is all valuation of the larger parcel.
This is valuation of it's valuation of the 10 acres by reference to the larger parcel.
Sure.
What I'll come on to say in the context of the Board of Assessment's decision is that they decide that in fact it's not the larger parcel, it's the smaller parcel. Then they effectively say, if you disregard that, and go on to consider the 10 acres on their own, not as part of any parcel. And that, on any view, in my respectful position, can't be sustained.
Right.
So the fact that the board decided that the relevant larger parcel was parcel 100 on its own rather than 100 plus 126 doesn't, I say, disable me from saying, well, the Board of Assessment nevertheless got it wrong, even on their own way of looking at it.
But isn't it for you to make a case on the 110?
Well, my lord, I was going to make the submission later, but I'll come to it now since you raise it. The question arises, in my submission, what should the Board of Assessment have done? The chronology, I think, is that the written submissions that went in at the end of the hearing itself took place in the summer of 2014, with a couple of further days of hearing in November 2014. Written submissions went in January of 2015, and then the board didn't give its decision until April of 2016. Now, my submission in this context is that if the board was going to take the line of saying actually the correct parcel is not the 361 acres, but only the 110 acres, only parcel 100, then at the moment that they made or were minded to make that decision, they ought, in our submission, to have indicated that to the parties. They should have realised at that stage, well, actually, now we have a difficulty because we've got valuations based upon the development project being this very large site. We've found, in fact, the development project would have been, or the area we're concerned with, would have been a smaller site. And they don't follow the logic of that through. They could have gone back to council and said, well, what's the impact of that for our assessment? Well, as I'll seek to show, what they do instead is to go off on a complete tangent and say, effectively, we're going to ignore all of that work that we've done on finding which is the larger parcel and just assess the 10 acres. And well, my submission that simply can't stand.
They took the other report. They preferred the report of
Mr. Childs.
Yes, but Mr. Childs was valuing the 10 acres as 10 acres with no reference to the fact that it had any development value other than development on its own as a residential area for local people. So he didn't take any account of that, and that's the error that it's.
But why is the board not entitled to regard the evidence of Mr. Glean as defective because he's effectively looking at the wrong target, and prefer the evidence of Mr. Childs, which is fully reasoned through,
because
admittedly in relation to the 10 acres, but Mr. Glean was going through his elaborate exercise to value the 10 acres.
Because the board's task is to assess the adequate compensation to which the claimant is entitled, and Mr. Childs' assessment doesn't result in that. That's the problem in my submission. So it may be right to say, yes, Mr. Glean's isn't quite right either, because he's starting from what we, the board, have now found as a slightly false premise, because he thinks the development area was bigger than actually we found, or he thinks the relevant larger parcel was bigger than we say it is. But that doesn't allow them then to say, well, therefore we must adopt what Mr. Childs says. Mr. Childs' assessment has to be right as well, and
this is a very different.
It's based on the wrong premise.
Did you make this submission to the Court of Appeal?
Well, in the Court of Appeal, there was a challenge to the decision that the larger parcel was only parcel 100, and that failed because the Court of Appeal said, well, it was an assessment on a point of fact, and we're not going to disturb it. And this further appeal to this board doesn't take issue with that. But that fact by itself doesn't justify what the board did. That's my point fundamentally.
It boils down to what the highest and best use was of the 10 acres. And to decide that, you have to decide whether you're just looking at the 10 acres or whether you're looking at the 10 acres as part of a coastal parcel of land, in which case the highest and best use might be tourism, or it might not. But just looking at this table on page 687.
Yes.
Am I right in reading that the acreages here are almost all less than 1 acre of land that was bought for these sums of money? that right?
Well, that's what, yes, you can, well, the first one is 2, the second one 4.24 and so on. The second column shows the acreage of these lands.
Yeah.
And what he's doing is extrapolating
What he
from that
then
what
does,
the value per acre must have been.
He extrapolates that to create the cost per acre and then multiplies that by 361 to get to the value of the plot. But in a way, you could just multiply those by 10 instead if you thought that the development was feasible.
I suppose possibly one could, but can I take the board to how in fact he did it, because it's helpful to set it in context so as to see what it was that was being said to the Board of Assessment. So those are the figures on page 687. Then at 689, at the bottom, towards the bottom of the page, he says that that there need to be, well, in the bold text about a third of the way up, he looks at what the average is, effectively, of the acre, the cost per acre. Then at 10, he says there should be qualitative analysis and adjustments. And he talks about accounting for the differences due to physical characteristics and the desirable combination of the impact of both size and topography. While the subject property rises gradually from the coastline to an elevation of one of the notable hills, the comparables are basically smaller, relatively flat coastal properties. The fact that the subject property runs from the coast all the way to the notable hilltop makes it much more desirable than the comparable, as the elevated sections not only enjoy the best views but also serve as a crown or picturesque elevated focal point for the overall property. That upper band, ground elevation of 50 feet of prime lands, is what gives the property its uniquely appealing character. So he says in order to compensate for that difference, the comparables are adjusted upwards but still within the range, and he says that you should take the top 5% of the market range shown above. So then he, paragraph 11, then sets it out simply on the basis of before acquisition. So he says the larger parcel, the 361 acres, is valued at 472,910,000 on the basis of a value per acre of 1,310,000. Therefore, the value of the part taken is 1,310,000. Now, that, of course, includes within it, going back to the discussion that we had yesterday about the role of severance and how it comes into play with the before and after method, that in a sense will include a degree of severance, because it includes within it it's avowedly not the value which somebody would pay just for those 10 acres considered on their own, irrespective of any other uses to which you might put them in combination with anywhere else.
I don't think Mr. Glean treats it as including severance, because
his terminology is, well, his terminology puts it slightly differently.
So his methodology, I mean, having read through his reports, all of them last night, seems to be you start with the large parcel, work out what the value of that is as a parcel, divide then by the number of acres in that parcel, and then say multiply by 10 to get the what he says is the market value of the 10 acres. He does that separately from then assessing severance and injurious affection, which he treats as a completely separate exercise applicable to the remaining lands after you've taken out the parcel.
I agree. We see that at the bottom of 690, where he goes and talk about remainder value after acquisition.
It's not really a before and after valuation.
No, it isn't.
Well,
Since he doesn't go original land, retained land, A minus B equals value of land being acquired. He goes original land, derive a value per acre and apply it to the land being acquired. You don't really need the value of the remainder for the purpose of, he doesn't use the value of the remainder as a way of getting to the value of the land being acquired.
No, that's right. In fact, what we see if we follow it through is that he does do a calculation for the value of the remainder, having been diminished. This is what we see at paragraph 12 by virtue of the fact that it's had this 10 acres lopped off it.
Yeah.
He says, paraphrasing paragraph 12, which runs over onto page 691, he says essentially the lopping off the 10 acres means that the remaining land is worth less.
But it's a very complicated way of getting to what is ultimately quite a simple sum that he's doing.
Yeah, well, maybe, but...
He's working out the price per acre and multiplying it by 10.
But I think we need to follow it through into how this is then presented to the Board of Assessment, because the presentation to the Board of Assessment doesn't precisely follow actually what Mr. Glean says.
But even the remainder value, that's just an arithmetic result from the first and primary part of his assessment, which is what's the value of the 10 acres, which he arrives at as a pro rata part of the wider parcel.
Yeah.
And obviously, if you take out the 10 acres, you're left with X minus 10 acres.
Yes.
And that's what is the remainder.
Not quite, my lord, because he goes further and says that actually the value of the remainder is reduced by the fact that it doesn't have the 10 acres as part of it. This is what he says at the top of page 691. I don't want to spend very long on this because it doesn't ultimately feed through into what's put to the board, but he says, taking all the relevant factors into consideration, this new inability to develop the most visible, highest elevations, the best view, most desirable, most marketable, etc., would have the assessed effect of reducing the value from a position within the top 5%, in other words, his 1,310,000 per acre, to a position among the lowest 20% of the range of prices.
But forgive me, isn't that his assessment of injurious affection of the remainder?
No, because he's not considering there anything about the land's value being diminished by some particular use that's being made of the bit that's been taken, which is injurious affection. He's simply saying
This is really a severance calculation.
that's a severance calculation. He says you take this 10 acres off. That means what's left is worth less than 1,310,000 per acre.
But what he doesn't seem to ask, going back to our discussion yesterday about before and after, what he doesn't seem to say is, would somebody in November 2003 have paid less for parcel 110 without the 10 acres compared to what they would have agreed to pay with the 10 acres? He seems to be trying to have his cake and eat it in a way, and that he both assesses the value of the 10 acres in an arithmetical way, and then adds on to that in some way the real before and after difference.
Well, he says it in the passage we've just been looking at. He is effectively analysing what he thinks. He doesn't spell it out in these terms, but he's talking about market value. So he's talking about what he thinks somebody would have paid per acre for the remainder of the land.
And he's saying the jewel in the crown has been chopped off.
The crown's been, that's right, the jewel in the crown isn't there anymore. So that's why, and that's how he gets to his figures, which we see at 13, damages, severance and injurious affection, although in fact it's not really injurious affection because he doesn't deal there separately with the fact that you've got aeroplanes flying over it and so on. He just says the value of the larger parcel before acquisition, this is the bold bit, about two-thirds of the way down, is 361 acres times that multiple. In other words, the full value of the whole land, in his view. After acquisition, it's been knocked down to $945,000 an acre, so that gives you the loss.
He's doing a partial severance calculation, namely severance so far as it affects the retained land.
That's
he doesn't
right.
need to do a severance calculation so far as it affects the land being acquired, because he's already valued that for the purpose of the value of that land at its optimum value.
Yes.
Yeah.
So that's why he says.
If I may, I do respectfully question whether he is saying in section 12 that he's valuing something with the crown jewels chopped off, i.e. the 10 acres, because he's talking about an estimate of the value of the property not taken, considering damages to the remainder property by reason of the taking and construction of the Wallblake Airport expansion project. And it's the construction of the project which brings in new planning restrictions, or so that's the case, which then affects the extent to which there can be building on the high ground anywhere within the extended area.
Well, it is.
And that's because he's already said that if you take the large parcel, there are lots and lots of areas of high ground which make it attractive. It's not just the 10 acres we're talking about. But what he's talking about here is the overall what's left being brought down within, not being in the top rank of these resorts, but in a position among the lowest 20% of the range of prices.
Yes, I mean, he's not entirely clear to what, when he says that, when he says in the conclusion to that section, top of page 691, he says, taking all the relevant factors into consideration, this new inability to develop the most visible, etc., part of the land. He's not clear there as to whether he's meaning inability to develop that part of the retained land because of the airport, or whether he's meaning inability to build on it at all because you don't own it anymore because it's been taken off you by the government. Logically, it could be both, and it may well be that he's got both in mind.
It may be both, but
Yeah.
I concede that Lord Sales is right.
Yes, I think
my oversimplistic analysis because of the paragraph starting essentially on the previous page.
Yes, that's right. That's right. But at all events, what is well, we can see what he says at the end. You end up with a compensation breakdown at the foot of 691. So compulsory purchase of the 10 acres. He takes he takes 10 acres at the full value of the land as development land. And as for the reasons that we discussed yesterday, I submit that in principle that, whether it's not expressed as such, but in principle that must include an element of severance. Because if you look solely at the value of the land in terms of what a purchaser would pay for it, then and this is I think is your lordship's point about the term. The purchaser of land which is capable of being developed with neighbouring land would pay more for it as a result of it being such land, but would not necessarily pay the full acre per acre value of the land, because of course that purchaser would themselves be looking to make a profit somehow. So there would be a gap there for a profit margin. So in the only way to get the full compensation to the person whose land has been taken, with some left over, is to add on effectively what's sometimes called on the case is the marriage value. And as the Law Commission's explanation of this we looked at yesterday makes clear, you can, as it were, short circuit that by simply taking the full value of the whole of the land per acre, and then unless there's some reason to think some acres are particularly worth more than others, which requires an adjustment, but subject to that, you can take the full area of the whole land at the full development value, the value that somebody would pay for all of it on the basis that it can be developed, and then look at the proportion which has been taken and value that proportion as a proportion of it. So anyway, that's the way it's put by the expert in that report. I'll come back in a second as to how that's dealt with in the submissions to the Board of Assessment. Can I just give me one moment, look at one other reference, and then we'll get to that. So I just wanted, if I may, just to take the board briefly, just to look at what Mr. Childs said, because this feeds into something I'm about to show the board from the written submissions. Mr. Childs, in his report, himself actually talks about both the principles of compensation and, in fact, before and after. And we see that if we go to 4377, which is in the colour copy of Mr. Childs' report. Just to set it in context, if you flick back a page, you'll see it's section 5, valuation methodology. And his first proposition is that the basic principle of compensation is that the person from whom the property is being taken should be no worse off, but also no better off as a result of the land being taken. So he essentially agrees with the submission that I was making yesterday about what the ultimate objective of this is. Yeah. And if we then go through to 4380, we see that he has a section entitled Commentary on Valuation for Compulsory Acquisition, about an inch or two down the page. I think, sorry, that's towards the bottom of the page.
Page
4380.
Thank you.
And he says the Land Acquisition Act in Anguilla does not address heads of compensation, severance, injurious affection, disturbance, and limited guidance to valuers. And he says, well, the valuation for compensation for compulsory purchase must be guided primarily by the Act. Established valuation practice from elsewhere in the Caribbean and the UK would help establish the general principles of valuation for compulsory purchase, We have therefore summarised below some of the main issues regarding the valuation of compulsory purchase, which are contained within the Land Compensation Manual prepared by the UK Valuation Office. He gives the reference to that. And then the next section you can see, method assessment of compensation, method of valuation. The before and after approach to assessing compensation should generally be adopted, he says here, as a means of valuation in compensation cases, although compensation is apportioned between land taken, severance, and injurious affection. And then he explains some more about that. The value of the land taken is assessed at the amount that would have been realised if the claimant had sold it into the open market to a willing seller. Where only part of the claimant's land is taken, the value should be assessed as part of the whole, disregarding any diminution in the value of the land required, resulting from its severance from the whole. So at that point, he seems to be at idem with the approach that I've been, and which was being put, more importantly, at the level of the board. But anyway, as we see, we've already seen, he doesn't in fact follow that through into how he actually values the land. There's one other reference in there. I just want to, it's a slight digression, but it's relevant to an issue which I criticise the board for not having considered properly, and that is financial feasibility, or feasibility generally of the project. And my lord, my lady, we see this at 4385. Valuation 1, compensation for land taken. And under the heading highest and best use, we see three headings concerning what, on reading them, it's clear, are criteria that affect whether the overall development project would have worked or not. He says legally permissible, and he says while planning consent for the master plan of which the subject property formed a part was not approved, we consider it reasonable to assume that outline planning consent for the scheme would have been approved, subject to a favourable environmental impact assessment. While we cannot comment on the conclusions an EIA would have drawn, we note that the W.S. Atkins National Study prepared in 2000 concluded in the environmental section of the report on Wallblake Airport that there are no records of any flora or fauna of any special ecological importance in this area. Other forms of residential development are also likely to have been approved, subject to restrictions on height as a result of the transition zones, both at the end and to the side of the runway for landings and takeoffs, which had existed for many years. So, broadly speaking, he is certainly not saying there, well, this was just unworkable in planning terms. On the contrary, he says it would have been approved subject to environmental impact assessment, and as far as we can see, he doesn't think there are any reasons why that wouldn't have been granted. Then he talks about physical possibility, which comes out essentially okay, hasn't got some of the challenges that other islands in the Caribbean have, like being volcanic and mountainous. And then financially feasible. He says the question of whether a development scheme is financially feasible is crucial with respect to resort residential development in the Caribbean. As at the valuation date, 28th November 2003, the question of financial feasibility for a resort development with limited and no beach frontage had not been proved. A number of well-known resorts had been developed on quality white sand beaches, and he talks about them. On an island, he says at the end, where resort development has focused on beach proximity, it is questionable whether this site is suitable for a resort residential development, which will require a significant infusion of infrastructure prior to the sale of real estate. The subsequent experience of 2007 has emphasised the importance of financial feasibility as it relates to resort residential development. So I hope it's a fair summary of that, to say that he doesn't quite say, well, it couldn't work, but he says it's questionable. And he sets out very briefly there why he says that it's questionable, whether it would have worked or not. He was asked about that in cross-examination, and if the board wouldn't mind turning to page 1141, tapping in 1141, we can see what he says about that. This is him being cross-examined. And did you form a view on that plan of the proposed development on that plan? Well, the plan as presented wouldn't have been financially feasible. So he, in his oral evidence, ratchets it up a bit and says it wasn't financially feasible. Why do you say that? The plan includes an inland marina, and with the site conditions down there, there is and that inland marina was the core of the plan, and without having to do any, actual feasibility, anybody who's worked in marinas knows that the plan would never have been financially feasible. That essentially is...
You had to build an inland marina.
I'm sorry, Emily?
Did the plan include building an inland marina?
Yes.
Yeah.
And then he goes on to say that Mr. Astafan then asks him about this. Did you look at the 2007 plan? And he say that one didn't contain a plan for a marina. But as far as we can tell, and I'm sure my own friend will fill in any gaps that I've inadvertently left in this, as far as we can tell, that's really all he says about financial feasibility of the project. He says, well, anybody, without having to do any actual feasibility, anyone who's worked in marinas knows the plan wouldn't have been financially feasible. That's that. Now, I flag that not to seek to re-argue the point and get a finding out of the board as to whether it would or wouldn't have been financially feasible, but to illustrate the fact that was an issue between the parties. And as we'll see when we look at the Board of Assessment's decision, they skirt that completely, because on their approach to things, it doesn't matter whether that plan would have been financially feasible, because they're only looking...
Did Mr. Glean discuss, I mean, he just assumes that it could be a high-end tourist development, and then he extrapolates from the values for beachfront and coastal property. But is there any discussion in his reports about his assessment of whether it was financially feasible?
What he does is, in his report, he refers to the developer's financial feasibility study. Admittedly, some years later, the reference is 112, which he says is exhibited, and he exhibits admittedly much more recent document, which is the developer's financial summary. That's at 204. It's 2011.
That was when it had changed over to Jumeirah.
That's right. So, I mean, it's much later, but on the other hand, it's still relevant, because, one does the same sort of exercise. Obviously, the economic environment may have changed, but in terms of what you need to do physically on the land to make it into a tourism development, that won't have changed fundamentally between 2003 and 2011. So that was his evidence. But importantly, in my submission, it's never put to him in his cross-examination, well, you just got this all wrong, and actually the whole thing wasn't financially feasible. So it would have been open to the Board of Assessment, had they been thinking about this, to have reached the conclusion that actually Mr. Childs was wrong and Mr. Glean was right, and that this project would have been important. The important question is, what would have been the position in 2003? That in 2003, on the 28th of November, a reasonable seller and purchaser would have between them worked out that this was a financially feasible project.
What I find so puzzling, Mr. Rowe, is that if my recollection is correct, the ordinary way of working out whether land has a development value, i.e. whether its ordinary or best use ought to be identified as some form of development, is based on doing a residual valuation. Your side did a residual valuation and then didn't deploy it. The other side don't appear to have done a residual valuation, and the thing is being looked at on the extraordinary high-level basis of whether or not you had to build an inland marina, which one plan did require and the other didn't.
Yes. Well, I'm not sure I can. I'm not sure I can add to that observation, Mal. I mean, it's undoubtedly the case that on both sides, probably fair to say, there may be criticisms to be made about the way in which the case was presented. Yeah. The Board of Assessment was faced with what it was faced with and had to come up with a conclusion that was open to it legally on the basis of the material before it, and our submission is that it didn't.
Well, I suppose we're still just in the final stages of the run-up to your telling us.
That's right. Now, yes. Can I go to the... Well,
just so we have the complete, as complete a picture as we can at this stage, page 4386, you showed us the passage from Mr. Childs on page 4385, but in fact, his discussion of highest and best use continues over the page, where he talks about maximally productive. And there again, he says, we've questioned whether the Conch Bay development site is suited to a comprehensive resort residential development project, given the amount of infrastructure would be required, particularly as the site does not control the beach, as other resort developments on Anguilla do. So, I mean,
Yes,
there again,
you're right. In fairness, he
giving
also says that.
reasons
So it's not completely fair to say
why it's not going to work as a resort. And then he goes on to explain that he concludes that actually the highest and best use for the 10 acres is possible residential development.
Yes. Well, I agree. That's what he says. But he still. I mean, even there, he talks about that. That's all looked at through the lens of my job is to value the 10 acres. I won't rehash all the references to that because they're in the Board of Assessment's decision. They quote his evidence, which in fact is that as a matter of law, he says all the cases and the authorities say you must only look at the site that's being valued.
That's not what he's done. He's considered, when considering what the highest and best use is, of this 10 acres, he's considered, is the highest and best use all that you can do on this 10 acres, or is it actually regarding this 10 acres as part of the larger parcel, in which case its highest and best use might be part of a high-end tourist development. But he says no, having looked at it, he doesn't think the project is feasible, so then that wouldn't be the highest and best use for any of the 110 acres. It would all be only capable of being used for something else. It's not just looking at the 10 acres.
But perhaps, my lady, I overstated the case a little, but equally, I think respectfully, I'd submit perhaps your ladyship's question overstates it the other way. I mean, the context of this is we know from his oral evidence, which is quoted in the Board of Assessment's decision, that he says, as a matter of law, I am obliged only to consider the value of the 10 acres. I'm valuing it only as 10 acres and not as part of any larger parcel. And so one has to keep that in mind in my submission when one reads what he says here in the report about the highest and best use. And he doesn't say anywhere in the report, actually, the development would never have worked.
What's the point of this whole pages and pages of discussion of the feasibility of the project?
Well, it's not very clear what the point of it is, because his ultimate approach is to ignore all that altogether and say, as a matter of law, the cases are very clear. I've got to value it on its own and not as part of a larger parcel. So he contradicts himself to some extent. But my point is that at this stage that there is an issue between the parties about the feasibility of the site, and he is only saying in the report here that he questions whether what he says is the larger parcel, which is parcel 100, and well, it's not quite clear actually. He says it was part of a larger parcel 100. A question whether the Conch Bay development site, which has been used by most people to refer to the whole site, is suitable to a comprehensive development project, etc. And then goes on to say what he says about this particular land. But my point is that one needs to keep in mind when reading that his approach, so he says, according to his oral evidence, is that by law he's required only to consider the 10 acres as a standalone plot.
But it seems bound up with his assessment that it doesn't make sense to look at it as part of a larger plot, because there isn't going to be a better, higher and best use for the larger plot. I just question whether it's a bit unfair to say that he contradicts himself, because at page 4388, so a couple of pages on, he specifically says, he refers to severance, and he says that we don't consider assessment of compensation for severance to be relevant. I mean, that seems to live with the point that it isn't going to be feasible to have this, in his view, to have this more general development.
Yes, I see that.
And that then drives him down to focus just on the 10 acres. But if you don't regard it as acquiring value on a severance basis from its association with the larger parcel, in a sense, what else can you do than look at it as a 10-acre block of land and see, well, how could that be used?
Yes, and and one can see that if as a matter of a factual determination, the Board of Assessment had looked at it in that way and had said, well, we consider that really, on any view, there was no prospect of development. I mean, suppose you just had a case where it was obviously a complete cock and bull story to say I was thinking of developing this land because it was obviously unsuitable for development. Then in those circumstances, of course, as a finding of fact, you would simply say, well, the factual finding is this development wasn't feasible that's proposed by the claimant, therefore I'm just going to value it as ordinary land. As we'll see, I hope, when we get to the judgment of the Board, they don't do it that way. They approach things on a different basis. Now, I was going next to go, if I might, just to the written closing submissions. As I mentioned, I think that the hearing finished in November. These were put in January. But by both sides, I won't go to the attorney's submissions, but they essentially say you look at the 10 acres and that's what you do, and you adopt Mr. Childs's approach. But the written submissions of the claimants are at 1441 and following. They start by talking about the historical background, and we've looked at the evidence briefly at the evidence of Mr. Lake yesterday. So I won't belabor that point, particularly in view of the clock marching on. They then set out a series of issues at 27. And I agree there's no reference there to specifically what is the value of the claim for severance. But then they go on at 1449 to talk about the question of whether in the case of a partial taking, the value of the larger parcel or the whole must be ascertained in order to determine the unit value of the land taken. And they set out some authority about the test of value, which I needn't linger over, and then 1812 of the Act is set out. And down on page 1450, at the top of the page, we see the assertion, which is correct if one looks at certainly the passages of the report that we just looked at. Both experts agree, drawing on the principle expressed in section 3.2 of the LCM, that the before and after approach to assessing compensation should generally be adopted. This is quoting what we just looked at from Mr. Charles's report, as a means of valuation in compensation cases, although the compensation, etc., is a portion between land taken, severance, and injurious affection. And then they quote the rest of that passage. And they say that sets out a clear instruction as to what's to be done. And then they say, it's surprisingly, the experts are polarized on what this principle requires them to do. 35, Mr. Childs, on the other hand, while he affirms the principle, which is a reference to that passage of the report, admits under cross-examination he did not undertake a valuation of the 110 acres in parcel 100. That's the passage that we know is quoted in the board's judgment. He admits he valued the 10 acres as a standalone parcel, admits in cross-examination there were no 10 acres before the scheme, so the entire parcel would have to be valued on the before the scheme approach. And they go on to criticise him for doing that. They refer at the bottom of that, towards the bottom of the page, to the New Zealand case where the before and after approach was taken, and they describe that case. And at 40, you get the assertion that having regard to the valuation evidence and the governing valuation standards enunciated by both of the experts, this being a case of partial taking, the valuers were required to value the larger parcel in order to ascertain the market value of the 10 acres of land, eventually retained by the government. Mr. Childs acted in violation of the valuation standards and principles that governed him in the preparation of his valuation report when he failed to undertake a valuation of the larger parcel before acquisition in order to determine the unit value of the lands acquired. Then there's a section all about what the larger parcel was, which makes a reference to the Australian cases about amalgamation and fusion of different parcels, urges the conclusion it was the larger parcel. Then at 1453, what was highest and best use properly determined, what were the highest and best use? And it said, Glean and Childs agree that essential for determination of market value of land is a determination of highest and best use. They reference the case of Rhodes and Corporation and Love, which just tells us you have to look at the highest and best use. And then down onto the next page, 1454, they also agree on the definition of highest and best use. They cross swords, however, on what is the highest and best use of the larger parcel, and therefore what is the highest and best use of the lands taken in assessing its value and in determining damages for injurious affection and severance. And then they explain why, on the claimant's case, the parcel is the big parcel, and why the highest and best use of that parcel is tourism. 54, they explain that Mr. Glean and Mr. Childs found that the use for the lands as envisioned by the claimants was legally permissible and physically possible. In fact, Mr. Glean in his analysis found the proposed development was not only physically possible but ideally suited for it. They agreed that the family's planned development for the forest estate satisfies the first two tests. It is therefore unnecessary to dwell on those limbs. Mr. Childs and Mr. Glean part company on the financial and maximally feasible limbs. Mr. Glean concludes after extensive discussion and data analysis that the family's proposed use of the forest estate for resort development was financially feasible.
So they at least did understand that Mr. Childs was saying not financially feasible and not maximally feasible.
Yes, because by this time, of course, they'd had Mr. Childs' oral evidence where he asserted positively that it was not financially feasible because anybody who knew anything about marinas knew this wouldn't work. And they criticise him for that. 56 onwards, they explain that he said it wasn't financially feasible and go on to criticise him for that conclusion. And they refer to his cross-examination at 57, say it was a broad sweeping statement that arbitrarily selects the marina as the core of the plan and pronounces that it is not financially feasible, because anybody who has worked in a marina would know that, which we respectfully submit was a fair criticism. On this absurd and irrational basis, he concludes that the entire planned development for the forest estate was not financially feasible. And they go on to lay it on thick in criticism of him for having reached that conclusion. And they criticise him for saying there was limited beach frontage. And they say at 59, apart from the smaller private beaches that would be available within the project, he takes no account of the fact that a 20-foot public road is all that separates the development from access to a substantial and pristine beach. This goes back to my answer to your Lordship's question yesterday about, I think it was Lady Rose's question yesterday about what separates the land from the beach. It's a 20-foot public road. Anyway, they go on, they criticise him in that respect. They refer to the undisputed evidence of Mr. Lake that the company later on got $12 million in deposits from actual sale contracts worth over $72 million, as the figure they put there. And so, therefore they urge on the tribunal that the highest and best use was development. And then they ask about what about after acquisition, and they say, well, it's unchanged but diminished. And then they go on to other...
I'm sorry, just to be clear,
yes.
It's the highest and best use always on their case for the 360 acres. So I don't think
yes,
they ever put
don't
forward any positive case about the highest and best use of the parcel 100, which is 110.
No, because they don't... Yeah, that's right. They are anticipating... they're working on the basis that they're putting a submission, it's 360 acres, and the consequences of that submission succeeding are this was prime development land.
That as we saw, the valuations that Mr. Glean took were valuations on fractions of an acre. So one couldn't say, I can see that if his valuations had all been based on 400-acre sites, and what was the value per acre of a 400-acre site or a 350-acre site, and then one was saying, well, actually, this is only 110-acre site, it's not 361 acres, then one can see that there might be a relevance to the fact that you're looking at a smaller thing. But as he's taking valuations that are for, at the most, 4 acres, and then not, it appears, treating the size of the site as relevant to the value per acre of the site, but just multiplying that by however many acres you are, I'm not sure it makes that much difference whether to Mr. Glean's analysis as to whether you're dealing with selling 110 acres or 361 acres.
Yes, well, I respectfully agree. I mean, he clearly, in an ideal world, somebody else in Anguilla would have recently sold a 360-acre site to a developer, but in the real world that didn't happen, and it couldn't happen because this was one of the points that was being made by the claimants. So this is one of the last potential development sites left on the island. It's a pretty small island, and
I'm
this is all that's
having
left.
trouble. We still haven't got to your punchline.
No, we haven't. I must make progress. I'm sorry.
11:15.
I was trying to give shorter answers to the questions. I'm sorry.
I think we really do have to go
We
straight.
do. We do.
We have to finish
Can I just go straight then to how it was put, and then I will go to the, because I need to do this because it's different from the way Mr. Glean puts it in his report. The end of the submissions, 1483. What is the amount of compensation to which the claimants are entitled? This, I expect, is what prompted Lord Sales's observation to me yesterday. Well, there was in fact no separate claim for severance. They say the unit value of the 10 acres taken is $1,310,000. Total value is therefore $13,100,000, and you've seen that in Mr. Glean's report. Then they say lands injuriously affected, rounded substantially down to a minimum of 42 acres, times $945,000 per acre for a total value of. Now, that last figure is actually wrong. It's just arithmetically doesn't work. It's just a slip. And we see the correct calculation at page 1477, 134, paragraph 134.
Sorry, just give me that page again.
1477, my lord.
Thank you.
And this in fact is focusing not upon severance in the sense of the overall, in the sense that the remainder of our land is worth less because a chunk has been taken out of it. This is injurious affection, properly so called, based upon the 42 acres which its common ground were affected by the change in flight path of the aeroplanes. And they say there that Mr. Childs can be rejected. The only reliable unit value for the retained lands that it has before it is provided by Mr. Glean. 42 acres multiplied by 94,500. Now what's not, and that gives you the figure that they do in fact claim. What's not spelled out there, but must be implicit in it, is that 94,500 is 10% of 945,000. And your lordships may recall $945,000 per acre was the figure that Mr. Glean gave for the value of the retained land. So the calculation they put forward is to say, well, it's 42 acres that are affected, so effectively 10%, so you take 10% as a 10% diminution in value of those 42 acres, assuming they started off as 945,000. It might be said perhaps the starting figure should actually have been 1,310,000, which was the figure, the value per acre before the severance. But there it is. That's the way it's put. And to that extent, I think I am stuck with the correctness of Lord Sales's point that there was no distinct claim for severance, as distinct from what I say is the implicit claim for severance value, which is wrapped up in the way in which the 10 acres were calculated, which includes. Which doesn't merely say what would a purchaser pay knowing that this was development land. It actually includes the full value of the land, albeit pro rata.
Yes, although Mr. Glean in his report lumped severance and injurious affection together.
Yeah, well, he lumped a different aspect of severance which wasn't pushed in the final submissions together, but he also implicitly included severance within his 1,310,000 per acre.
So you say.
No, I say. Well, well, that's what I say. After that very long run-up, may I then actually turn to the board's decision? I'm sorry that it's taken me quite so long to get here, but I wanted to make clear where one gets there from. The decision is at 1888. There's a lengthy section where the board sets out the rival contentions. And they set out the ultimate calculation that is advanced by the claimant at paragraph 40 on page 1901. That's why I say there was the correction. And then they set out the respondent submissions, and then they come to the analysis section, which is in fact considerably shorter than the setting all out the parties' argument section. The analysis begins at page 1912. They say rightly at para 69, the Board of Assessment was faced with two very divergent claims brought about by two distinct methods of assessing the compensation that should be paid. They say at para 70, the Board's work is to assess, award and apportion compensation in such cases in accordance with the provisions of the Act. The Land Acquisition Act sets out the rules for assessment of compensation. My lords and my lady, in my submission, that's where this starts to go off the rails, because it's not correct, for the reasons I indicated yesterday, that the Land Acquisition Act sets out comprehensively, as is implied by that, the rules for assessing compensation. Nor is it right, incidentally, that the Board's work is to assess, as they quote there, in accordance with the provisions of the Act, if by that what is meant is that the Act tells them they've only got to apply the Land Acquisition Act. What footnote 33 tells us, that's the footnote that tells you what they're quoting from in paragraph 70. It's section 10, rather, of the Act. You can see it on page 4532. It's just the provision that gives the Board power to assess, award and apportion compensation in such cases in accordance with the provisions of this Act. But it's a procedural section. It's not saying the Board must only look at section 18.2 and disregard everything else. Then they quote section 18 itself, the first subsection of which they set out there. The rules set out in this section shall apply to the assessment and award of compensation by a board for the compulsory acquisition of land. And again, that wording is important. The rules set out in this section shall apply to the assessment. It doesn't mean that this act and this section sets out the comprehensive exercise that must be done, and that's that. As we saw yesterday, the law in this area is an amalgam of different rules from different areas. I won't go to it now, but I hope they reached the Board this morning. A couple of other authorities that I put in. Good, I'm glad it worked this time. One's the Antigua Constitution, which yes. I won't go to, but it's the one that makes clear the entitlement to compensation. And the other was the Spiro's case, where the House of Lords looked at this, and there's some quite helpful historical material about how we got to where we are, but it makes it quite clear there's not a comprehensive code. So I submit that actually at this point this all begins to go wrong, because they're looking at it solely in terms of the narrow question of section 18. Then they go on at 1913, paragraph 71, to look at the question of the larger parcel. And they explain that Mr. Glean referred to the larger parcel being the 360 acres. 73, they note, I only mention this because of something a learned friend said, they note the criticism of Mr. Glean's qualifications, and the point that my learned friend took, essentially a credentialist point, that he's not qualified to give that evidence, but they reject that. And they deal fairly briefly in 74 with this issue, and on the basis that the land is not under the beneficial control of a single individual or entity, the 10 acres that were acquired were part of a parcel owned by Dame Bernice Lake. I find as a fact, it should be we find as a fact, but whoever actually drafted it put it in the first person and it didn't get changed. I find as a fact that the larger parcel is of parcel 100, not 360. And there's an explanation briefly as to why that is. They're not a fused parcel of land according to the Board. And that's the reference to the principle of aggregation, which crops up in the Court of Appeal. Then we get to highest and best use. Both experts before the Board agreed that in assessing the compensation to be paid for the acquisition of the parcel, it was necessary to ascertain the highest and best use of the acquired land. The highest and best use of the parcel was claimed by the claimants to be that the 10 acres acquired was part of coastal lands. And I emphasise the word part of, because it plainly wasn't the claimant's admission that the acquired lands were themselves on the coast. They were part of the coastal lands because they were part of the overall potential project. They contended the tribunal had no reliable evidence for it to conclude on a different highest and best use of the 10 acres. and they set out what it is they were asked by the claimants to find. Highest and best use was the integrated use to which the family had dedicated as part of a larger tourist resort development. It would be an error to regard it, as Mr. Childs did, as an isolated parcel of land at the end of the airport, an airport runway suitable for local residential housing. And then you get this finding at 77. It stretches common sense and the facts before the board to hold, as the landowner urges, that the highest and best use of the 10 acres acquired was that of coastal lands. As described, the land acquired was 10 acres located in front of the airport and some distance from the coast. And I respectfully criticise that, because they really mischaracterise the submission. They turn their attention to what the 10 acres itself was. Of course, that land wasn't itself coastal lands, but they don't quote accurately what was being put to them, that it was part of coastal lands. They just say, well, those weren't coastal lands. Then they say, extraordinarily in my submission, the board accepts the expert testimony of Mr. Childs that the 10 acres can be assessed on a standalone basis. And the reason I say it's a bit extraordinary is because they then go on to quote Mr. Childs in cross-examination, where he says, and they appear to approve of this passage, this is down on the next page, 1915, it's when you're valuing the 10 acres of land, you're valuing the 10 acres. If it formed part of 100, it formed part of 100. I'm still valuing 10 acres. I'm not valuing 100 acres out of 110 acres. I think this is a fundamental issue that the tribunal needs to understand. The case law, the Act, is very, very clear what is being valued and what the instructions are. And they go on, apparently with approval, to set out what else he had to say about that. What this comes down to is whether or not the 10 acres had an independent marketable interest. I disagree that you have to value the entire parcel to arrive at the 10 acres. They say, it seems to us that Mr. Glean's position would more appropriately apply to the case where a strip of land was taken. In such a case, as Mr. Childs pointed out, you value it as part of the whole and you prorate the value of the strip. Mr. Childs' example is pertinent. It appears to be being approved of by the board here, and because he was asked what independent marketable interest means, and he explains by reference to the strip example. The question has no independent marketable interest, and he says that's what determines whether or not you value it as part of the whole. If it has no independent marketable interest, you value it as part of the whole and you prorate the value of the strip taken. If it has an independent marketable value, for example, in this case 10 acres, you value the 10 acres. It is very clear. And that all appears to be approved of as a proposition of law by the Board of Assessment. In my respect for submission, that's just flat wrong. For the reasons that I've already, I hope, made clear, we respectfully submit that's simply wrong. There is no rule of law, as the Board of Assessment appears to have thought, that if the parcel which has been acquired has an independent marketable value, then what you must do in order to assess the compensation payable to the landowner from whom it's been acquired is simply to assess that parcel on a standalone basis. And you cannot assess it as part of a larger parcel from which it was taken. There's no support for that proposition in the law at all in my submission, but that is explicitly the basis on which the Board of Assessment proceeded. And so from this point on in their judgment, they are thinking about the 10 acres as being a standalone parcel which needs to be valued as such. Then they go on to say at 80, the evidence before the board was that at the material time, November 2003, no planning permission of any kind was granted for or in relation to the 10 acres or otherwise. There was an application for planning permission which was pending an environmental impact assessment. And then they go on a bit of a tangent. They talk about the refusal of permission in 2011, but that's to do with injurious affection and we'll look at that in a minute this time, the statement that this is the 42 acres is a no-build area, which they say shouldn't be taken into account, and they hold that it's irrelevant. So, and what's curious about paragraph 80, I mean, it's with great respect to the Board of Assessment, indicative of perhaps somewhat less than fully organised thinking, if I can put it that way, because they talk about the 10 acres or otherwise. There's no evidence, they say, that planning permission is granted in relation to the 10 acres. Well, that's right. It's true also no planning permission was granted for the whole of the land, but they're very unclear as to what it is they're actually addressing there. And in any event, insofar as that is a finding, or if it's intended to be a finding, that the whole premise of the claimant's claim was wrong, because even if you looked at the 360, or even if you looked at the 110, there was no prospect of getting planning permission for a development, that's completely against the evidence. And if I need to achieve the standard that one needs to achieve in an appeal against a finding of fact, then in my submission I've accomplished that on these facts, because it's a hopeless way of looking at it in my submission in comparison to what the evidence actually was. I might have been in difficulty if there had been at this passage a reasoned analysis of the competing expert evidence about the financial feasibility of the project, and if the board had come up with a plausible reason as to why any fool know that a marina couldn't be developed was inaccurate, if they'd come up with a plausible reason for saying that was right. But they don't even go there. They just briefly touch on the subject in a rather confused way, where it's not clear whether they're looking about the 10 acres or the whole site, or what the whole site is. And in any event, it's simply one shouldn't try to imply out of it a finding that actually development was a non-starter in any event.
Mr. Rowe, I think we're going to have to stop you at 1:45 at the latest.
Very well. I think I can just about make
You might be on course. That's giving you as much of an overrun as your opponent.
Of course. Well, I'm grateful. I mean, I think I'm not far from getting there, but I'm very grateful. So, in my submission, my lords and my lady, that really doesn't justify the Board of Assessment's decision at all. They then, and of course they don't, as I've already said, they don't resolve at all the critical issue, which is whether Mr. Glean was right that the big project was financially feasible, or Mr. Charles was right that it wasn't. And the reason they don't resolve it, of course, I say really, is because whether they spell this out or not, or whether they fully understood this, I don't know. But the reason they don't need to resolve it on their way of looking at it is because they are just taking the 10 acres on their own as a standalone parcel, as they put it. And then they turn to 81. They say the Attorney General submitted that the highest and best use of the parcel comprising 10 acres of land located at the end of a runway will be residential development for Anguillan residents provided, etc., etc. This submission would appear to be more in accord with the facts of this assessment. Well, of course, once you've got to the position where you're looking solely at the 10 acres, then yes, one can see why they say that. Nobody's going to build a tourist development exclusively on the 10 acres. So that you're left, unsurprisingly, with that as the conclusion.
And one might say 110 acres.
Well, look, that's not in my respectful submission quite so obvious. And the Court of Appeal looked at this, and I did want, before my time is up, just to take the board briefly to what the Court of Appeal said about this, because the Court of Appeal is criticised for making its own finding of fact, as it were, in that context. I think I probably said everything I need to say about the decision of the Board of Assessment. Can I just take 20 seconds to make sure I'm not being, through lack of time, dissuaded from mentioning anything I need to mention?
But the heart of your submission on this reasoning is that they disregard the finding they've made as to it being part of Parcel 100, and are proceeding to value it in isolation.
Yes, that's right.
Yeah.
And it's not surprising that they reached the conclusion they do. No, I think the only other points I wanted to make about the Board of Assessment are in connection with the appeal, but as we've decided to deal with that separately, I'll deal with that separately, albeit briefly, later on. If we then look at what the Court of Appeal said, that's 2489, and I'm sure it's in the key documents bundle as well. The Court of Appeal, first of all, consider paragraph 12 and following whether parcels 100 and 126 were fused, and decide that essentially this was not a factual finding that they want to disturb. Then the court turns at paragraph 19, page 2500 to should the acquired land be assessed on a standalone basis. And cutting it shortly, the Court of Appeal says no. 24 is where this is explained. I have two major problems with this line of argument. The first is the parties made submissions and the board adjudicated on the question of whether the 10 acres acquired by the government should be treated as being derived from a larger parcel combining those two parcels. The board resolved this issue in the respondent's favour by determining that the 10 acres were derived from a larger parcel of 110 acres and not from the combined parcels together containing 370 acres. In paragraph 18 of the judgment, I upheld the board's finding on this issue. So in other words, what were they doing looking at that if it wasn't in fact relevant, as they then effectively found? And then 25, my second problem with this line of argument is that it makes a nonsense of the fusion and amalgamation principles. Now, this is criticised by our learned friends when they say, well, there are no such principles. But in fact, when you look at it in context, they're talking about, makes a nonsense of having thought about, it's really a repetition of the same point, makes a nonsense of having thought about whether you could treat these two parcels as one. And makes the point that the valuation of the acquired portion of land would proceed on the basis of the amount which it will fetch in open market, irrespective of whether it's an entire parcel of land, etc., etc. So I needn't and then there's reference there to the way the Court of Appeal reasons it is in section 18. I mean, it speaks for itself, but essentially they say, in a sense, it kind of ignores conditions that didn't exist at the time of acquisition of the land. So the standalone basis assumes effectively that the severance of the 10 acres has already happened, and then values it at that moment, whereas actually, conceptually, you value it before the acquisition has happened. Anyhow, there's then a lengthy section about the before and after method, which I needn't go through because it covers much of the same ground and reaches the same conclusion that I've already urged on the board. And then we go to page 2511, if we may. Paragraph 50, having regard to the prior determination that the 10 acres of land must be assessed as part of parcel 100 from which it was severed, it follows that the highest and best use formula must be applied to parcel 100 in its before condition containing 110 acres and in its after condition containing 100 acres. The question then becomes, what is the most profitable use to which the land could be put that is legally permissible, physically possible and financially feasible? Once it is accepted that the land being valued is the entire parcel 100 as it was before a portion of it was compulsorily acquired, and that although there are parts of the land which are proximate to the airport runway, there are also parts of it which are coastal lands, I do not believe that it could be seriously disputed that the land was suitable for tourism development, including high-end tourism development, and not just local residential development. The highest and best use, therefore, of parcel 100 is mixed residential and high-end tourism development. The task of valuing the land, though, remains. Now, my Lord, we've already accepted, of course, that the ensuing calculation, which they then do, marrying the two different valuations, etc., not having been put to the parties for comment before it became the judgment, it's necessary to, that's unacceptable, and it's necessary to remit the matter, because that wasn't an acceptable shortcut. I mean, the Court of Appeal plainly should have invited the parties to comment on that before they did that. So the judgment of the Court of Appeal has to be set aside. But as a general proposition, 51 is illuminating in my submission. This is a statement which the court, in particular, Mr. Justice of Appeal Michel, I think, who was the judge who gave the judgment, was perfectly entitled to make. And in my respectful submission, as a matter of common sense, there's quite a lot to be said for it. I won't go so far as to say it's plainly right, because obviously there may be arguments to the contrary about why parcel 100, as opposed to the whole lot, is ill-suited to tourism development. But one can see entirely in my submission why this is why the Court of Appeal says this, and in my submission they were perfectly entitled to say it. But in any event, it highlights the point that I make about this. I accept that the claimant submissions didn't contain a fallback analysis in case they lost on the question of which was the right larger parcel, and perhaps it should have done. But this is an exercise of assessment. It's not a trial on pleadings. It's an iterative process to some extent. The thing was dealt with on the basis of expert reports, witness statements, statements at the hearing, and examination in chief and cross-examination. And if the Board of Assessment was going to come to the conclusion that, well, actually the real parcel is 100, then in my submission what they ought to have done was to say, well, that parcel is suitable for tourism development, and if there was any concern about whether that was a fair finding to make in the light of all of the evidence, the parties not having addressed it specifically, and one can see why it might be, then the proper thing to do was to refer that back to the parties for their submissions. What they were not entitled to do in my submission was what they did, which was to adopt an entirely erroneous basis of dealing with the matter by saying, well, it's really all or nothing, and since the premise of the claimant's claim has been found to be unsound because the big parcel wasn't 100 plus 126, it was only 100, therefore we're going to adopt the other side's approach. That can't have been right in my submission.
I think we've got it, Mr. Rowe.
You've got the point, my lord, and I think my time is probably up, so I shall...
I have to call you short at that point.
Can I say one more sentence, which is to draw attention to the last paragraph of our note, where we ask the board respectfully, if I have persuaded your lordship and ladyship to remit the matter to a fresh board, to do so with an indication that it ought to get on with it.
That's fresh board with the existing evidence, is it?
It would be a matter for the. I think it would be a matter. That's a further matter for discussion, which I'm probably don't have the time now to go into, and not necessarily, I would say, because the whole premise of one aspect of what I've just been saying is that there wasn't necessarily before the board on one view of things everything they needed to do. So I wouldn't necessarily urge the Judicial Committee to advise that the board be limited solely to the evidence that was there, because we might want to say, well, Parcel 100 was okay for the following reasons, and they might want to say Parcel 100 wasn't okay for the following reasons, wasn't viable as a tourist development for the following reasons. So to that extent, I wouldn't submit that it should be strictly limited to the existing evidence.
Thank you. Mr. Clayton.
Thank you.
We're probably going to need to curtail your reply a little, because we've only been given 15 minutes anyway.
Yeah, I'll be quite brief, in fact.
Thank you.
It's important to appreciate that essentially the board rejected Mr. Glean's evidence throughout. It rejected his evidence about comparables, partly for the reason made by Lady Rose that the comparables were too small, but it gave other reasons in paragraphs 98 and 99, that's MS 1922. It accepted Mr. Child's view about the development value of the acquired land as being potentially a scrubland which potentially might be used for residential. But all of my friend's case is premised on something which he wholly fails to achieve, which is that they're premised on the basis that the correct value it should be to evaluate as high-end tourism. And in our submission, what is critical to appreciate is the weakness of the positive case which he advances. He hasn't asked you to study his documents about his positive case closely. I shall. If you turn, I think it's to page 112, which is the Glean first report, you will see what Mr. Glean does is rely upon what he describes as a feasibility study performed by the developers. An executive is attached at Exhibit 9. This feasibility says this financially concurred with the highest and best use. That point was put in cross-examination. I'm not going to take you to the reference before the board at 1071, and Mr. Glean accepted it. What in our submission is remarkably weak is the material which is Appendix 9 at N04. So I want to look at this because it doesn't begin to get high-end tourism off the ground. And you haven't studied this document at all. The first point to make...
Exhibit N, is that what
it's N, yes. And you'll find it at MS 204. The first point I want to make about it is this isn't a financial appraisal at all. It's actually a pitch to developers. I don't make a point about the fact it's dated 2011, save to make this point. It's all perspective going forward. And it's perfectly obvious from reading it that this proposal is at a very early stage. It is wholly unhelpful to the estate in trying to contend that as of 2003, this would have been developed for high-end tourism. It actually demonstrates quite the contrary. For example, what it shows us is that this particular month, March 2011, they signed management and branding contracts. That's paragraph 1. It refers, second sentence in the next paragraph, the property once developed will be branded. Turning the page to MS 205, if you would, the Government of Anguilla second paragraph, or first paragraph that appears, will comprise future tense, a top quality futurely integrated resort. Next sentence, the project is being developed. And then turning to the proposed construction loans, excluding the hotel component, which will be funded, again looking forward. Turning the page to 206, and the penultimate sentence in the first paragraph, the land for the hotel will be segregated, again use of the future tense. And then the bottom of 206, the equity, under the equity participation, it is proposed that an equity investor contribute $50,000, and then more detail. But the bottom line in our submissions is this case does not demonstrate that a proper positive case that the best and highest value should be for high-end tourism. And therefore, most of the submissions advanced by my friend, skillfully if I may say so, simply fails because of this, in our submission, significant hole in his whole case. The estate never could prove it had high-end tourism. Maybe it had an aspiration, and there are phrases which I've referred to before. It was an aspirational wish, and they raised finance on that, and then there were problems because of the crash, and they had to refund and so forth. But the bottom line is that they didn't have any evidence that this would be the use in 2003. So the suggestion that somehow or another the board simply didn't look more widely than the acquired land for development value is, with respect, wholly fallacious. It did look, it basically rejected the case the estate put to it. That's what it did, rejected it, as it was entitled to do. It was open to the board to say, we've considered the respective cases about the highest and best value, and we reject the case that the estate advances. And
we saw yesterday Mr. Lake's written statement about all the work that they've done.
yes,
Did he give oral evidence?
he did.
Was he cross-examined
He
about
was.
the feasibility of the...
No, well, he was cross-examined. I mean, he was cross-examined at some length and challenged, I think, is the fairest way of putting it. But at the end of the day, what the board was required to decide was that the estate had made a proper case that the best and highest value was for high-end tourism. And the short point is we submit that they didn't. And I'm not sure I need to say anything more.
Thank you very much.
Could I just ask one question? The runway extension had been built by January 2004,
Yes,
and it was operating.
that's correct. I think, yeah.
And so I'm just puzzled as to what's going on in 2011 with this proposal, if the effect of the airport expansion is to preclude the possibility of development.
Well, I'm not sure I'm best placed to answer that question, but basically you're right in the chronology that you've just described. But clearly the estate was still trying to raise more money because it had to pay money back, and it was still hadn't abandoned the idea of the project. But as I said in submission yesterday, the relevant question to look at is of a hypothetical buyer, and the fact that the estate had aspirations didn't really matter. They had to produce proper evidence about what their case was, and they simply didn't. I mean, really is as simple as that. And despite the somewhat elaborate submissions made against us at times, the case really is quite straightforward. We would respectfully submit on the facts.
Well, thank you, Mr. Clayton. Now, we've only saved ourselves about 3 minutes of the loss. We've got effectively an hour to finish.
Yes.
I think I'm going to have to lay down some revised time limits.
Sure.
I think 25, 25 and 10 is probably the fairest allocation.
Okay.
To be strictly
Starting
adhered.
at about 3 minutes to.
Be strictly adhered to.
Very well. I shall do my best. I was going, my lord, to get up and interrupt my learned friend's submissions, but I thought since I'm about to be speaking anyway, I would leave it until I was. But just to say, by way of further response to Lord Kitchen's question, it's not the claimant's case, it wasn't the claimant's case that the effect of the development was to rule out altogether the possibility of development. The case is that it's damaged the value of the development. So that's why there's no inconsistency, I say, between the fact that in 2011 there was a proposal for development and the claim that's being made. And I again, if I may just perhaps stretching your lordship's patience a bit, but just in relation to Lady Rose's question, we'll have a look at the cross-examination of Mr. Lake and see whether my learned friend's answer on his feet is one that requires anything to be added to in terms of what was said to him in cross-examination. But to address then what I'm actually supposed to be on my feet talking about, if I may, the appeal. This is a very short point, my lord, and I hope that I won't need even to take all of the time that is allocated for it. This arises from the board's decision, which we see at page 1923 and following. And whatever precisely had been said in the expert reports, by the time, as you've seen already from my earlier submissions, we got to the submissions before the board, what was being said was that there was a claim for injurious affection based on 42 acres of the land, having had each having had $945,000 worth of value knocked off them. And 102 explains the claimant's claim for injurious affection is based on their expert's analysis that 42 acres were completely no build, though he did not make clear either in his report or in his oral evidence the evidence which he based his conclusion. And they go on to criticise the way in which he gave his oral evidence. He said, I'm saying the area will be affected generally as the flight path. They refer to his response to the question. Is it your view, based on the valuation exercise you carried out and being aware of all the planning permissions granted and refused, is it possible for the developer to build on the 26 acres in question that was acquired? And he said no to that. Just before I'm perhaps leaping in too quickly to this, just in case it's not already clear amongst all the other facts in the case, the reason it's 42 acres is because you've got the 26 acres which were part of which were handed back in 2008. That's the chunk just to the east. But you've got another 16 acres which are affected by the airport because there's no reason it should. It doesn't coincide exactly with the land that was taken back in 2003 and then handed back. So that's where you get your 42 acres from. And
sorry, you said it includes the 26 acres, but 16 were handed back. Surely the 42 is the 16 plus other land, not the acquired land of 10 acres.
yes, not the acquired land. No.
Okay.
Yeah. No,
Because this is injurious affection.
It's injurious affection. That's right. The acquired land, you get your compensation for having it taken off you, and that's it. And they criticise.
And I am sorry to take up time.
No, not at all.
Can you show us on the plan which land we're actually talking about?
Yes.
Because I don't have it clear in my mind.
Let us look at.
4328 was what we were using before.
Yes, I think so. Let me just. I've got my paper copy of that one, which I find a little easier to deal with. Yeah, I think if you look at 4364, that should assist. This is transition zone for Wallblake Airport post-expansion 2004. So you can see on 4364 rather, you can see that by this stage the airport has been expanded to the east, and the yellow is the transition zone, and some of that goes over the acquired land to the left of the vertical white line, and then there's a parallelogram, albeit with a not quite a parallelogram because the one side of it isn't completely straight, but drawn if you it's that part of the land which is within the yellow, and on the right hand side of the white line, and within the
It's
red.
those two slices above and below the 16 acres that was returned.
But those are the extra bits that
Yeah.
top it up to
Yeah.
being the total that we're
Understood.
talking about.
Yeah.
I think.
It looks less than 42 acres.
Yes,
I don't want to take up time on this, but it looks quite a lot less than 42 acres.
I do see the point. I do see the point. I'm not sure I can constructively deal with that on my feet. We'll have a look at it. If there's anything that
Okay.
that we can deal
If you
with,
can help later,
briefly in
that
a
would be
note, then
appreciated.
we'll do that. But there it is. But anyhow, the controversy between the parties doesn't really turn on the precise measurements anyway. It simply turns on the proposition which was advanced by the claimant, that the effect of it was that in practice this was all an area of no build, and that as a consequence of the development it became an area of no build, and that therefore the value of the land was diminished. And the reason for that is obvious. I mean, this was discussed, I think, yesterday in the course of my learned friends submissions, but your lordships and ladyship are of course right that the reason the transition zone moves is simply because aeroplanes are now taking off and landing from a point which is that much nearer to the retained land than was previously the case. And of course, when you have an airport, you have to have an area for the planes to take off and land over. I think without wishing to give aeronautical evidence, which I'm not qualified to give, even if I was allowed to, I think probably we must be talking about landing rather more than taking off, I expect.
No,
because-
surely the prevailing winds here are
Absolutely.
from the east, so we're mainly talking about taking off.
Maybe, but
only have
perhaps I shouldn't confuse things. It may not
waves.
matter. It may not matter, but either way. Yeah.
Indeed.
Take off to the east, towards the east. Yeah, I'm confirmed. They take off towards
Yeah.
the east as they.
And the prevailing wind's about northeast through southeast in this part of the Windward Islands, isn't it?
Yeah. Well. Good. Anyway, either way, you've clearly got to have an area where the planes can safely take off. And our learned friends submission appears to be that actually the policy is, provided that you don't build too high a building so the plane doesn't actually clip it as it comes over, it's okay. Well, our submission is that's not backed up by the evidence such as it is, and we rely upon the materials that we quote in our written case. This is. I can take it probably mostly by reference to the written case. This is at tab 3 of the key documents, or 4286 if you're in the electronic version. And these are all documents we've looked at before, but maybe just go back to them briefly for the purposes of my making the point good, I hope. Page 4920, we set out the building height policy and guidelines.
4920.
4290.
Right.
Forgive me. And that in turn is a reference to 272 in the bundle. So if you want to see the prime evidence, as it were, then 272 is where you see it. We looked at this yesterday in the course of my and friends' submissions. Anguilla's building height policy and guidelines approved by the Executive Council 15th September 2004. And 272 gives you the policies. Policy Air 1. The Government of Anguilla will not permit development which will interfere with or be adversely affected by the operation of the airport, lies in the transitional surface and approach zone of the airport, penetrates the approach slope of the airport runway, is in any other way an obstruction hazard to aircraft approaching or leaving the runway. What it doesn't tell you is what the conjunction should be between the different paragraphs. And my learned friend seeks to get you to imply that the conjunction is and, but it must be or in my submission, otherwise it wouldn't make any sense. In my submission, its development in the area we're concerned with is ruled out by B, lies in the transitional surface and approach zone of the airport. And it doesn't say, as I think the board pointed out to my own friend yesterday, it doesn't say will not permit development brackets unless it's 2 stories or less. It just says will not permit development. There is policy HT1, which I think in the end my learned friend said that's the policy that he was referring to when he says it's a policy which is different, that was in place. But as I think Lord Sales pointed out in the argument, that says that applies to the areas surrounding the airport, which of course is not just the transition surface and approach zone. But at all events, we know in practice what this all means because we have the advantage of from an evidential point of view at any rate, the advantage of an actual planning decision, which the board has already looked at as well. And let me take the board to that. Let me go there if I can just find the reference via the picture of what it is that the planners were looking at when they decided to say what they said in answer to the application. Sorry, I just lost my reference. Just give me 1 second, I shall find it. I'm sorry, my lord, I had it to hand and I mislaid it and I'm trying to find it. Let me, while I look for it, can I take the board to the back to the document itself, the refusal itself? That's at 2725.
Now, this is 2011. I may be wrong, but I thought I picked up from my reading that the September 2004 height policy and guidelines have been withdrawn. Am I wrong? I could be wrong about that.
I don't think that's the case.
No. Okay.
Oh, did you say 725?
27, no, I may have said it, but I didn't. What I meant to say was 2725.
Right.
2725.
Thank you. Yes.
It's the unambiguous statement at paragraph 2 that we refer to in particular. The proposed development lies within the takeoff zone of the runway, which is an area of total restriction for all built development.
Depends what you mean by zone, I suppose. Whether it's a cone or an area of land.
I suppose there could be a distinction between takeoff zone and transition zone, I suppose, but there doesn't seem to be any evidence for drawing that distinction.
It's clear, is it, that the transition was in fact a plot of land? I think it's common ground that the transition, that what's referred to as the transition zone is that 42 acres. But I mean, whether that's okay.
The precise basis, though, I'm not sure I can give you on my feet.
Is the problem that in paragraph 1 this is saying that this is the reason why there's this restriction is to prevent future development which will interfere with or be affected by the future development of the Clayton J. Lloyd International Airport. That is future as of 13th July 2011. And your difficulty is that it's not saying that because of the way the runway is currently structured, there's a total restriction on all built development. It's saying we want to preserve the position for future development. And your difficulty is we don't know whether, as at 2003, there was already plans for yet further development of the airport, which, beyond the development that we've been talking about, which would require total restriction of all built development.
Well, this again comes to a question of conjunctions, but here we can see the conjunction is and. So it doesn't, on a fair reading of this, it doesn't follow in my submission that you have to read little Roman 2 as saying the proposed development lies within what may be the takeoff zone of the runway once we've expanded it, if we decide to expand it by reference, in the context of some future development. It asserts, as a separate reason for the refusal, that the development lies within the takeoff zone of the runway, which is an area of total restriction for all built development.
I see, and you don't say that one should read that as being a consequence of what's in little 1?
No, there are three separate reasons in my submission.
So you
I was just going to come back and try to find. Can I take one moment just to ask to be resupplied with the reference which I had, which I'm afraid I'd momentarily lost. Well, can I, rather than taking up lots of time, which I know the clock is ticking, can I?
What's it you're looking for?
All I wanted to show you was the yes, the Lordship may know it. I wanted to show you just the plan of the proposal, just so you can see what it is that was being turned down.
2736, and I think the location is 2731. So it would be helpful just to check that the location is indeed within the cone you showed us.
Yeah, Your Lordships. I got that quite right. I'm grateful.
You can't tell from that quite where it is in relation to the cone.
Well, I think this is perhaps when it helps to have a printed copy as well as the computer copy, isn't it? Let's have a look.
Yeah. Oh, wait a minute. That's better. 2731
2731.
may help because you can see the airstrip, and you can see
That's
the
right.
development in relation to the airstrip.
Okay.
Yeah, and in fact, if you compare. And you can see that there's an existing building to the right, Leonard Kentish Residence.
Which page are you?
I'm looking at 2731.
Yeah.
Yes.
And turning it round 90 degrees.
436.
One second. In fact, if one looks at, if you're able to look at that at the same time as 4364, perhaps you're not, because it depends on whether you've got a printed copy of the report as well. But if you're not, if your Lordship would just look at 2731 for a minute, you can see the Leonard Kentish Residence, and then you can, if you just visualise for a moment and try to remember where the four new houses or the new houses are plotted. In relation to that, the new ones, the proposed houses are those.
They're mainly in the 16 acres handed back, and possibly a bit of them just to the north of them.
Possibly, yes.
It certainly looks as though the sort of bottom two are within the cone, and that may be all you need for
Yeah.
your point.
Yeah, I mean, you've already got there. You can see, it helps to cross-reference them by looking on 4364. You can actually see the Leonard Kentish residence. It's the white building just to the right of the handed back land. Yeah. So you can see that's got a little spur of road going out to it.
Where is the plan again? Which page?
Oh, yes, I see.
It's on 47273.
You're right. So it is, I think, mainly in the 16 handed back.
Yep.
Yep.
Yeah, it is mainly in that area, but it's in that area quite a long way. If you look, another aspect of this is to keep in mind, I submit, is that the distance of those proposed new houses from the eastern end of the estate, well, of the eastern end of the estate, and therefore they're actually the furthest back from pretty much on that plot there. They're not quite at the very far back boundary, but they're not very far from the back boundary. So if you can't build those there, then logically you certainly can't build them any nearer to the runway.
No.
And there's really no basis in my respectful submission for concluding that actually we're wrong about all this and there was some less fierce planning policy that said it was fine as long as it was only 2 stories. And that really is the point. And the board of assessment didn't really deal with it properly in my respectful submission. They don't seem to grapple with this, and they got it. They based their decision on their criticisms of Mr. Glean's oral evidence, where they say that they quote him. This is the top of 1924. The question was, thank you, I'm not sure it's the point was being made, but I think out of caution I should put it to you, is there any part of the land the subject land's impossible to build on? No, they're not. And we submit they just misinterpreted that answer, because it's clear when one looks at it in context, he wasn't addressing this question. He was just talking about, was it impossible to build on the whole area pre-scheme? And you pick up the reference to the transcript, it's 1075 and 1076. I'm sure I can see that.
Yep.
I went, given the time, I went trawl through that aspect of that part of the transcript, but in my submission, it's not fair to say that his evidence was neither clear nor credible, as the board did, and they simply missed the point. And there's been really no credible rebuttal to the contention that we respectfully make, that it's quite clear that the effect of the scheme was to render those 42 acres a no-build area, in our respectful submission. And there's equally no suggestion, and there could be no suggestion on the evidence that it was a no-build area before the scheme. Somewhere in the evidence, and I was trying to find the reference, but I can't, but if I get there, I'll let you know that there is reference to the fact that in the 1990s, before any of this question of the airport being expanded, arose an apartment was built towards the west end of the acquired plot, which would suggest that there was no reason to, at that stage, no reason to stop development. I've just been passed a reference. Let me just check that it's the right one. Oh yeah, it's 3250. Map showing George Lake two-storey house and other residences in the vicinity of the old Wallblake Airport in February 2003. I don't think this point is actually controversial, but it just goes to make good the proposition that before the scheme came along, there was no difficulty in building in that area. It was the scheme coming along that introduced the no-build policy. Lord, I think those are my submissions, unless there's anything in this context that you think I ought to add.
Thank you.
Or deal with. Thank you.
Is there any questions? No? Yes, Mr. Clayton.
My lords, my lady, yesterday we went through Mr. Child's evidence, and I'm not going to say anything more about that, but it's important in our submission to read his evidence together with that of Mr. Proctor, who gave planning evidence for the government. And we could pick that up at 573.
I'm sorry, you muttered that last number. I couldn't hear it.
Sorry, excuse me. It's let me just find the beginning of it. It's the report begins at 537, MS 537. It's a report on possible blight and planning decisions of the Conch Bay development by Mr. Vincent Proctor, the Principal Planning Officer. And if you pick it up at 545, beginning at Roman 6, the department, that's who the DPP are, provide a comprehensive building heights policy approved on the 15th of September, was intended to create a balance, etc., around the wall of Arabon that was to establish long-established controls. The extended runway as constructed when compared to the previous one did not provide any significant variation in the position of the transitional zone. The runway was pre-profiled from a height of 86 feet to a height of 77.58 at the displaced threshold, albeit there was a gradual decline, so the transitional ratio of 1.25 allows for development to the height of a single to two-story house. Dame Bernice Lake was refused planning permission in July 2011 to construct two four-story houses in the approach and takeoff transitional zone. Whereas the proposed site was not suitable for two-story houses, it would have been suitable for single-story residential developments. So that's what's said. And then if we can...
Did Mr. Proctor give oral evidence?
Yes. So I understand it, yes. And then...
And is the heights policy that he's referring to in Little Roman 6, is that what we were looking at just now?
I think, yes, that's correct. I think the confusion for which may be our fault, is that we dealt with it in the submissions yesterday solely by reference to Mr. Child's evidence, but in fact, there was specifically planning evidence called.
So this, he's talking about a transitional zone ratio. But where does one get that from? Where does he get it from?
Well, the transitional zone ratio forgive me, is the conclusions he draws from the transitional zones which we've looked at. They appear in that the photograph, which incidentally I should have said earlier, we have a...
Sorry, which photograph?
The at 4 to...
4364.
Yeah, yes, that's right.
Is the 1.1 to 25, is that the degree of the slope that you're talking about? I just say that because on road gradients it's often expressed.
Yeah, it's a transitional slope, so it's a three-dimensional concept.
Right.
That helps.
Okay. Where's it come from?
I think it's simply a methodology which applies from looking at the transition zone, as I understand it. That's how you apply it. Can I also say, just because I failed to mention, I think we do have bigger illustrations of the relevant photographs. If they're of any interest, we have A3 size reproductions of the relevant photographs that we've been looking at. If we could next turn, please.
Well, how does Mr. Proctor square that with the policy itself that we were looking at, page 272?
Well, all I can say, I think, in fairness, is that a consistent thread of his evidence is, because I was about to take you to other passages, is that it's no build. And let's remember the issue here is...
Sorry, it's no build.
The consistent issue is it no build, or is there scope for some building?
Yes.
And his evidence is that there is scope for building single-story houses.
My question is, how does he square that with the policy on page 272? Policy Air 1.
Well, as I understood it, it was to do with height. If you're below the height line.
But my question really is, looking at policy Air 1, cold, just as a text, it seems to say the Government of Anguilla will not permit development which lies in the transitional surface and approach zone of the airport. So the point being made against you is that reads like an absolute prohibition on building.
Yes.
And reliance is also placed on the planning decision in 2011, which also reads as though it's an absolute ban on building in the transitional zone.
I'm constrained. I'm afraid I'm simply constrained by the evidence that was given. And as I've said, the evidence that was given is that in fact that zone permitted construction of one-story houses. Yeah. Well, yes. I think. Well, that's the high point. I say. Because it's about a gradient, if you're below the gradient, takeoff gradient, then that's permissible.
It says what? What makes it permissible?
I'm afraid I can only rely on the evidence that I have from the planning department.
Okay, thank you.
That's the answer. And if you could please turn to 570.
570.
Sorry, it's 570. That's also in Mr. Proctor's evidence. it talks at Roman 5 onwards. The applicant was aggrieved at the refusal of permission, didn't appeal. The proposed development was the construction of two-story buildings in the transitional zone. The height put approach would have some adverse impact on aircrafts approaching and taking off, therefore rule on public safety. But the proposed site is suitable for single-floor development. Single-floor commercial and industrial residential are permissible developments in this zone.
I mean, well, just what I'm struggling with is there seems to be a mismatch between what the policy said and what Mr. Proctor seems to be saying.
Well, he acknowledges at subparagraph 6 that it was in the transitional zone of the runway.
He does.
So it appears to fall absolutely foul of Air 1 sub B.
Well, unless you read that as a point that Mr. Rowe was making, that they are cumulative, that it lies in the transitional surface and approach zone of the airport, and it penetrates the approach slope of the airport runway, which would make sense. There's no point in restricting development if it doesn't penetrate the approach slope of the airport runway. And perhaps Mr. Proctor was assuming that it's got to both lie in the transitional surface and approach zone and penetrate the approach slope. And his calculation of the approach slope indicates that a one-storey building wouldn't penetrate it. And it may or may not be in any other way an obstruction or a hazard to aircraft. That may be how Mr. Proctor was reading it.
Yeah, I think in fairness to Mr. Rowe, he was saying you should read it disjunctively.
Yes, I think that's the question.
Well, I think with respect, this is the point made by Lady Rose appears to be the way in which Mr. Proctor understood his policy. Yes, and just give me a moment to. And that approach is consistent with Roman 6 at page 545, which we just were looking at, about the policy creating a balance between maximizing use and preserving safety.
Right, but the policy isn't just in relation to the approach zone, is it? It's about the surrounding area.
Well, I agree, but the inhibition, so in a sense, the point being made by the estate is a wider point. It's not just there's no build in one place, but it's more generally. And our answer to that is to say, well, it's not no build in the area which is most closely affected by the airplane takeoffs. And
can I just ask you about the policy again, page 272?
Yes, can you just give me a moment to get it?
Sure. Do you have it, Mr. Clayton?
I do.
What's the meaning of the approach slope in little c? Penetrates the approach slope. So that seems to be different from the approach zone.
Yes.
Well, just give me a moment. Yeah, it's the gradient of the airplane as it takes off, as I understand it. So it's a more specific point. So if it interferes, encroaches into in effect, the zone which an airplane might cross, it's prohibited. Which is why something which is below it is permissible.
Yeah.
Right.
I mean, A, B, C, and D are, with respect, very unclear, because D does look like an alternative.
I accept they are. It's not the clearest of phrasing, but in our submission, what the estate have to show is that its effect is that there should be no building at all. And in our submission, it doesn't have that effect. It's not a total prohibition on building. And that's the way it was applied and understood by the planning department.
But it's not how it was applied by the planning department, because in 2011 they refused an application giving as a reason, ostensibly, that there was no building permitted.
Well, the language of the decision, I accept, is not happily phrased, but our understanding of the position is it was rejected, not on the basis there should be no building at all, but that it was too high.
So does it come to this, that although there are these statements of planning policy, you're saying that Mr. Proctor is well placed to say what the actual practice
Yes.
was, which seems to have arguably departed from the actual policy, but I suppose you can depart from policies,
Yes.
and therefore the true position is as should be taken as Mr. Proctor describes it.
Precisely so. How did I take you to page 570? I'm sorry if I...
Yes, that's what we've been looking at.
Yes, sorry, yes, that with respect, my lord, that is the submission that we make, is that whatever the position as a strict matter of construction, the policy was applied in practice in a particular way, and we'd invite the board to approach the finding of the Board of Assessment on that basis.
Can you remind me what happened in the Court of Appeal? Did they
The Court
simply...
of Appeal found in favour of the government on the point.
Yes, yeah.
So in effect, we're in concurrent.
Well, that's why I asked.
Yes.
Yeah.
So we're in that territory anyway. So what I was simply focusing on was trying to explain the basis for it. But this was an area where the Court of Appeal, I'm grateful, my lord, but where they found in favour of the attorney.
And was there any evidence given of planning matters on behalf of the claimants?
Not as far as I'm aware.
Well, I prefer a firmer answer if you could.
But obviously, if I may state the obvious, the fact that the Court of Appeal was satisfied on this issue is an important starting point in the way this board should approach.
Well, if it's just factual and involves no error of law, then I can see why you say that.
Yeah.
And was Mr. Proctor cross-examined on any of his explanation of what happened in fact as a matter of practice?
I think so. Sorry, can I just...
Starts at page 1284.
Thank you.
Yeah. Well, he made a correction in chief, it appears, but we don't know what that was yet.
He certainly was cross-examined, and he wasn't shifted from the position that he took. The cross-examination about the actual decision begins at 1304. And 1302, and in fact, he didn't resolve from the position he expressed in his report. Well, you can see from the transcript the basis upon which he was cross-examined.
Oh, yeah. So, well, he is being asked to explain why the letter said what it did, even though he's saying you can have one-story development.
Yes. But I said he doesn't resolve from that, and he's cross-examined about it.
He refers to something called a safeguard map. Do we have that?
It's not immediately to hand. You'll have to. I think if we have it, we'll have to come back to that, Frank.
He's obviously looking at a document which has different zones with different colours, which indicate different things that could be done on it. We haven't been shown that.
Must be here somewhere. Well, can I locate it in the bundle and send you?
I think that's what we'll have to do, Mr. Layton, but
Yeah.
do it today if you would.
Yes, I shall.
Thank you.
Thanks.
Well, thank you very much. We're getting ahead of timetable after all that. Mr. Rowe,
My Lord, very, very briefly. I think I can-
concurrent findings?
Well, concurrent findings of fact, the approach the court that this board should take to that depends upon the nature of the issue in each case. Obviously, if there is an issue which turns upon assessment of oral evidence, particularly at trial, and the court of
Yeah, but
looked at it as well, then
our well-known practice is rather more rigorous than that.
that was only the start of my submission, my Lord. I agree. Well, your well-known practice is more rigorous, and I see one of the cases in the authorities bundle as a recent case where I was on the wrong end of it. So I'm not unfamiliar with it. This is a short, however, point in my reflective submission, which, I mean, whether strictly speaking one describes it as a question of fact or not, it's really a point of interpretation of the policy. And what you're presented with is, in my submission, this straightforward position. The policy, I say, is perfectly clear on its true construction. And at any rate, what its true construction is a matter of law. So whether it's clear or not doesn't really matter as long as I can persuade the board that I'm right about it. And in my submission, the true construction of the policy is that there is a no-build zone which covers the 42 acres.
Yeah.
So that's what the policy says. The fact that some evidence was given by a planning official who says that, well, actually, a one-story building might have got around the no-build policy is nothing to the point, in my respectful submission. Even if that evidence was factually accurate, that doesn't alter the proper approach to the question which we're concerned with, which is what is the assessment of compensation for compulsory purchase. If the effect of the scheme, which has injuriously affected my land, is to bring into effect a planning policy that says you may not do such and such a thing on the land, then when I go to try and sell my land to a hypothetical purchaser, which is, I'm saying this for the purposes of talking about its value, and the hypothetical purchaser says, well, look, I've just looked up online what the planning policy is for this bit of land, and the answer is you can't build on it. It's not going to cut much ice if I say, oh, yes, but actually, if you speak to Mr. Proctor in the planning department, he'll tell you that as long as you only keep it down to one story, you'll be all right. It doesn't help at all. So in my submission, that is why the finding by the board ought to have been straightforwardly that the policy means what it says. I appreciate there's perhaps a degree of ambiguity in the way that it's worded, but as a matter of fair reading, I say both the policy is clear and indeed the refusal, which refers to the policy, is clear that whatever other considerations there may or may not have been, for the purposes of the 42 acres, the rule is simple: no build. That is what the finding of the board ought to have been. The board went off completely on a tangent and addressed their minds to it on the basis of the perception they had that the oral evidence of Mr. Glean on this point was unsatisfactory, which seems to have been simply the result of a misunderstanding, I submit, of his evidence. So it's not like one of those cases where the first rationale for the concurrent findings rule really kicks in. I mean, the Das and Marchand recently, the case I just mentioned, Lord Burroughs in that explains the rationale of the rule on behalf of the board. I think some members of which are present here. And one of the rationales, of course, is that by this point there will already have been two proper considerations of it by the courts below. Well, if the first court didn't look at it properly, then that immediately detracts from the force of that. If the second court then, in the Court of Appeal, just casts it aside as one point and says, well, it's a factual finding, that's that, then it has even less force. Of course, it still has some force, and I've got to do rather more than just persuade you that you might have taken a different view of things. Yeah. But in this case, I submit that the point was a straightforward one, and it was a point in relation to which, and this is perhaps a point that applies to everything that I've been saying in the course of this appeal and cross-appeal. These were deliberations by the Board of Assessment and then the Court of Appeal concerning fundamental rights. This was not two people who voluntarily got into a contract with each other, and now one of them is quarrelling about the court's interpretation of a dispute they had about the contract. My clients didn't ask to have this land taken off them by the government. It was taken off them by the government, and therefore they had a fundamental right under the Constitution to have adequate compensation for it. And in my submission, that factor ought to inform the court's degree of willingness or unwillingness to intervene. Well, may I take a moment just to check with my colleagues that I haven't made any glaring omissions that I might put right in the next 12 minutes? I hope the answer will be no, but if I could take a moment, I'd be grateful. Well, I'm grateful. Those are my submissions.
Questions? Yeah, well, thank you very much, Mr. Rowe. We're grateful to all counsel for the depth and quality of their oral and written submissions, and in particular to them for the speed with which they got through the estate's appeal, which made up for the loss of time taken up largely by questioning from the board on the first appeal. The board will take time to consider what advice they will humbly tender to Her Majesty.